Were you disappointed when the Biden administration's parole in place proposal for undocumented spouses of U.S. citizens was canceled, was terminated by the federal courts? If so, you're either an immigrant, an undocumented immigrant married to a United States citizen, or you're a United States citizen married to an undocumented immigrant. And now that parole in place is gone, after you've been waiting for such a program for many years, you're wondering, what next? What do I do? What options are there? In this presentation, I'm going to share with you two options that you need to know about. So let's get started. To begin, I'm going to assume certain things. There were 5 key requirements for the parole in place program. I'm going to assume you meet these requirements. Now, how much you met them, I mean, if there were little quirks and you had some problems, well, you may also have some problems with some of these options I'm going to discuss. But I'm going to assume, for purposes of helping you understand these options, I'm going to lay out these 5 areas just to begin with. The first was that the immigrant had to be an undocumented immigrant in the United States. Couldn't be someone here on a visa. They have to have arrived without permission and be living in the United States without permission. The second requirement is that they have to have been here for 10 years prior to June 17, 2024. 10 consecutive years, 10 continuous years prior to that date. Third, the undocumented immigrant had to be married to a United States citizen before June 17, 2024. Fourth, the undocumented immigrant was going to be required to show good moral character. And the undocumented immigrant believed that he or she could do so. Fifth, the undocumented immigrant had to show the government that they merited, that they warranted favorable discretion from the government, a favorable adjudication so that they could be granted parole. Now, assuming those 5 requirements are met, there's 2 different programs that you should be thinking about. One is purely defensive, cancellation or removal, and that occurs in immigration court. And that's very important because a lot of individuals are now placed back into the shadows of American society, sort of like hoping that they don't run into problems with the government, and they're referred to immigration agencies. Cancellation removal for undocumented immigrants is like a last stand defense. It's if all goes wrong and you end up in immigration court, then you can assert cancellation removal. And based on the 5 parole in place requirements I just noted, I'm going to show you how they'll apply to your case. The second is something that many individuals that were very favorably looking upon parole in place had already thought about, and that was filing an I-601 waiver. The immigrant would have to go back to their home country for their interview. But prior to going home, they needed to win a waiver, an I-601 waiver, so that they would have the permission to come back in. So that's the second option we're going to discuss. And again, I'm going to show you how the 5 parole in place requirements leads me to believe that most parole in place applicants that would have met the requirements of parole in place will qualify under either one of those 2 programs. I'll begin with cancellation or removal. This is an interesting program. It only occurs in immigration court. This means that if you're picked up by immigration authorities and they send you to the detention center and then they serve you with some papers to go to immigration court, you can request cancellation removal. In that sense, it's a defensive filing. I call it the last stand defense because if an individual, an undocumented immigrant, has no other form of relief that they can seek, then they can still claim cancellation or removal. So Cancellation removal is an important program for many, many, many immigrants to know. Let's see how the parole in place requirements match up with cancellation removal requirements and why I believe that there's a good fit there. If you were eligible for parole in place, you are likely eligible to seek cancellation removal. The first requirement is that the individual seeking parole in place had to have been an undocumented immigrant. Under cancellation removal, undocumented immigrants can seek cancellation removal, but so can those who enter the United States with a visa and then they overstayed. So cancellation removal is a little broader. But as long as you came in as an undocumented immigrant, you meet the first requirement. The second requirement is that the immigrant under parole in place had to have been here 10 years, dating back from June 17, 2024. Under cancellation removal, the requirement is 10 continuous years in the United States. But the days you start counting backwards is the day that you're served with a document called a notice to appear, which is summoning your immigration court and giving you an outline of the charges against you. So if you were to be picked up tomorrow and placed in proceedings, then you would start counting back from there. So if you met the 10-year requirement from June 17, 2024, it's very likely, unless you've left the country, you meet the requirements for cancellation removal. The third requirement under parole in place is that the immigrant has to have been married to a United States citizen. Well, under cancellation removal, you have to have a qualifying relative, someone in your family that would suffer an exceptional and extreme hardship. And it's limited to certain persons. It's limited to a lawful permanent resident or U.S. citizen, spouse, parent, or child. So again, cancellation removal is broader. But if you are married to a U.S. citizen spouse, then that qualifies you to seek cancellation removal. So you can check that one off. Requirement number 4, under parole in place, is good moral character. So really what you're looking there for is disqualifying crimes, disqualifying actions. With parole in place, the rules were made very stringent so that almost any felony would count against you. In immigration court, under cancellation removal, the restrictions in terms of criminal convictions are not quite so strict. They're looking for crimes that immigration considers aggravated felonies. I call them, to make it more understandable, aggravated immigration felonies, because they may not be a felony under state law, but they're a felony for immigration court. Also, under immigration court, you look at crimes of bad moral character, bad moral turpitude. But if you meet the more stringent requirements, again, under parole in place, then you would meet the requirements under cancellation removal in all likelihood to show good moral character. The 5th requirement under parole in place is that of you had to win a grant of favorable discretion. That means the government looks at things subjectively. In immigration court, as I noted a few minutes ago, you have to show exceptional and extremely unusual hardship to a qualifying relative. But in my view, the factors the government would look at under parole in place to see whether you merit favorable discretion, and the factors to show that a family member, a qualifying family member, would suffer hardship, are really closely related. Almost like the factors of discretion are turned 180 degrees. Consider, under parole in place, if a person's been here and they've gotten very strong letters of support from their employers. They've been a good worker. They've contributed to their community. They're married to a citizen and they have children. They're raising a family and the children are doing well. Well, those are going to be factors of discretion. And the way they would weigh discretion in parole in place is it's like a scale. They balance it. The bad acts push that scale down. What are the bad acts? Entry without permission, living here without permission. And then the good acts come in. Raising a family, taking care of them, taking care of U.S. citizens, contributing to the community, contributing to your employer, staying out of trouble. That's how they would balance it. Now, in a hardship analysis, they're going to look at the same kinds of factors, except think about it. If those factors are positive in an exercise of discretion, and the government says, those are good merits. Well, they're also going to be that if they're stripped away from the family because the immigrants deported, they're going to be hardship to the family. They're going to be hardship to the wife. So putting those together, it's really closely related, almost the same. And I believe that if an immigrant merits favorable discretion under parole in place, all those factors can go into a hardship analysis at immigration court to show that the family, that the U.S. citizen spouse would suffer an exceptional and extremely unusual hardship. Now, of course, because there's discretion involved, the officer or the judge could say, well, yes, there's hardship, but it's not exceptional and extremely unusual. Or they could say, yes, there's a lot of good merits, but we don't believe that on the whole it merits discretion. Okay, let's move on now to an analysis of the I-601A waivers. The analysis whether an individual who qualifies under parole in place or would have qualified under parole in place also meets the requirements for an I-601A waiver follows closely the same analysis as with those who would seek cancellation removal. However, there are some differences. So let's begin. The first requirement is that the individual seeking the I-601A waiver had to have been an undocumented immigrant. Well, that's true because the whole reason for an I-601A waiver is that the person has to return home for the interview because they're here without permission. They entered without permission. Therefore, even when they have a U.S. citizen spouse that wants to sponsor them and wants to petition them for benefits, they have to return home for the interview. If they want to come back to the U.S., then they're going to have to seek a form of forgiveness, which we call a waiver. It's a permission to return to the United States. Now, the second requirement is that the individual has to have lived in the U.S. for 10 years under parole in place. Well, that's not a requirement under 601A waivers. However, under a 601A waiver, an individual has to seek that. An immigrant has to seek that if they have lived in the U.S. more than 6 months without permission. Then they have to seek an I-601A waiver. That allows them that permission. It gives them that forgiveness so that they can come back into the United States. The third parole in place requirement is that the individual has to have been married to a U.S. citizen. And that's also true, would also fit with a 601A waiver, although the spouse in a 601A waiver could have been a permanent resident. And the immigrant could have also qualified if their relative had a qualifying relative that was a parent that was a permanent resident or U.S. citizen. But having a U.S. citizen wife does give them a qualifying relative so that they can seek an I-601A waiver. The fourth requirement is that a good moral character. And like cancellation removal, certain things are going to come into play that will restrict someone from earning permanent residency. But again, the requirements, much like cancellation removal, are not as stringent as they are under parole in place. Minor crimes should not affect them in a way that they affect the parole in place individuals or applicants. So, again, good moral character is a necessity. You must demonstrate good moral character. And the fifth parole in place requirement is that of favorable discretion. And with an I-601 waiver, again, the favorable discretion is exercised really within the context or as a result of a hardship analysis, except that in an I-601A waiver, the requirement is extreme hardship, not exceptional and extremely unusual. Now, personally, I believe that an extreme hardship, if we were thinking about it just in terms of the language used, is a higher hardship, a more strict hardship than the cancellation removal hardship. However, courts and officers, USCIS officers have not seen it that way. But I think when I look at hardship, that whether it's called exceptional and extremely unusual, or it's called an extreme, it's a difficult hardship to meet, and it's based on accumulation of factors. And those factors, as I noted earlier, are really just the same as the favorable discretion factors, but turned around 180 degrees. So again, if someone that has been here without permission, has been a good parent, has been a good family provider, has contributed to community, and there's other things that would happen to the family. The children might have to forego their educational dreams. The wife may have to forego some career she's seeking, or husband might have to forego some studies that he's taking. Well, then that is going to be hardship. But the fact that the family is even thinking that way would be favorable factors of discretion in a parole in place analysis. And so when you think about these two programs, cancellation and removal, and the I-601A waiver, to me, if someone qualifies or would have qualified for parole in place, they would have a good chance of prevailing under either of the other two programs. That's a lot of information to digest. So let me go quickly through the parole in place requirements as they match up with cancellation removal requirements and I-601 requirements one final time, just so that you can see how it all fits together. The first requirement is that the immigrant must have entered the United States without permission. Second requirement, the immigrant must have lived in the United States for 10 consecutive years. The third requirement is that the immigrant must be married to a United States citizen spouse. The fourth requirement, the immigrant must demonstrate good moral character and the absence of disqualifying crimes. The fifth requirement is the immigrant must show that he or she merits a positive grant of discretion. As they match up with cancellation removal or the I-601 waivers, you'll see that each one of those five requirements, with slightly different twists to them, show up in those programs. In fact, those five requirements show up over and over and over again in immigration programs. So if you know those five programs, with some modification, depending on what you're seeking, they are the key to immigration success. If you're ever detained and forced to represent yourself, or you're forced to defend yourself in immigration court, or if you file an application and you're challenged by a government official. Know those five general requirements. They were set forth for parole in place. Parole in place is dead, but they are a very good outline for whatever actions you want to take in the future. If you can demonstrate those five requirements and make sure they're specific to what you're seeking, you have a very good chance of prevailing and eventually becoming a permanent resident of this country. With that, I want to wish you the best of luck. I wish you the greatest success going forward. And I hope that you become a permanent resident and years later you take the next step and become a United States citizen. Take care and good luck. Thanks for watching. Know someone who might be interested in this video? Then please take a moment to like and share it with them. Also, if you would like more videos on immigration, just click on the subscribe button. And here's a little bonus, a short guide that you can download for free by clicking on the link on the description box or the square-shaped image. Plus, if you have ideas for videos you'd like to see, write a short comment below or feel free to contact me at carlos@VitaraImmigrationLaw.com. My name is Carlos Vitara. I appreciate your time and hopefully we'll be talking again very, very soon.